What is the Violence Against Women Act, or VAWA, and how to apply for it? In today's Tip of the Week video, we are going to talk about this act, who can apply for it, and what is the process like. I'm immigration attorney Andres Mejer, and if you don't already know me, I'm an immigrant myself. I came to this country with my family, and for a long time, we didn't have legal status. We fought hard to get it. We were scammed by people and lawyers arguing that they were going to help us, but in the end, we only lost money and time. If there is a mistake you can make while dealing with the US immigration system, we did it at least once. And even though there were hard times, that was what motivated me to become a lawyer and help people have a smoother ride to achieve their American dream. So, the Violence Against Women's Act, or VAWA, was passed by Congress in 1994 as part of the Violent Crime Control and Law Enforcement Act of 1994. This was made to recognize the severity of the crimes associated with domestic violence, sexual assault, and stalking. Today, you can apply for a permanent lawful residence, i.e. a green card, if you are the victim of battery or extreme cruelty committed by your spouse, who is either a U.S. citizen or lawful permanent resident, or if you are the spouse of a U.S. citizen or lawful permanent resident and she or he has abused your child, or if a U.S. citizen or lawful permanent resident parent, including a step-parent, or a U.S. citizen adult son or daughter. So basically, you have to be a victim of battery or extreme cruelty, and it has to be committed by one of these people: your spouse, and your spouse is a citizen or a green card holder, or your spouse or green card holder abused your child, or your parent abused you, and your parent, even if it's a step-parent, was a citizen or green card holder, or your adult son or daughter was a U.S. citizen, not a lawful permanent resident. Now, the cases that we've had where it was your children is usually children who suffer from a mental condition, who are bipolar, who have other impulse control issues. Those are the cases that we've seen, and we've seen successful. They are by no means the only ones. As you can see, not only spouses can use this opportunity, but the children and parents of the abuser may also seek this type of protection. You may self-petition the VAWA by filing a petition for a Marasian, widower, or special immigrant. It's Form I-360, without your abusive family member's knowledge or consent. See, typically, these are family-based applications where your parent, your spouse, or your child is filing for you. However, if you suffer from battery or extreme cruelty, you still have to prove the relationship. But if you prove extreme cruelty or battery, you can file on your own. That's why it's called a self-petition. A person who files a VAWA self-petition is generally known as the VAWA self-petitioner. If your self-petition is approved and you meet other eligibility requirements, you may be eligible to apply to become a lawful permanent resident right away, or you may have to wait for a visa. There are 4 steps you need to take to get your green card on the VAWA. The first one is for both immediate relatives and preference relatives, and that is the visa petition. In this step, you'll need to prepare a petition on your USCIS Form I-360. For this petition, you must include supporting evidence such as marriage or birth certificate and proof of the U.S. citizen or lawful permanent resident status. However, because the self-petitioner must prove the abuse as well as legitimacy of the relationship, like marriage, gathering all the required evidence might take longer. The process may seem complicated, and if you are doing it alone, hiding it from your abusive family member's knowledge can be scary, but you don't have to suffer any of this. In cases like this, having a backup of a lawyer can make a huge difference. You can use another person's address, a safe address in the United States, to protect yourself in case you are still living with the abusive person. However, long-term, you should not continue living with an abusive person. It will cause you problems when you ultimately file for citizenship. At this point, the process splits in 2. The preference relatives submit the visa application to USCIS as a separate package and must wait for a visa to become available, while the immediate relatives can combine it with their application to adjust status. So, what we're talking about is a family-based application generally has 2 components. One is to document the relationship, and second is the change of status. So if you've suffered extreme cruelty, you have to document the relationship and prove extreme cruelty. Under some circumstances, you can also file for the change of status at the same time. So if you're a preference relative, what that means is The person applying for you typically is not an immediate relative, which usually means they're a lawful permanent resident. Because the spouse and child of a U.S. lawful permanent residents are not always immediately eligible for a green card, sometimes the visa is available, but often it's not. They sometimes submit a visa petition to USCIS for approval before going any further with the green card process. Upon receipt of your I-360 visa petition, USCIS will typically within 30 days issue a notice of action. It's called Form I-797. We refer to it as the receipt notice. This contains a receipt number as well as a priority date. We will talk about the priority date in the next step. Unfortunately, USCIS tends to take longer to decide an I-360 because it must review all the included evidence. Once the petition is approved, USCIS issues an approval notice. Now, USCIS approval of your I-360 does not in and of itself provide any legal status in the United States. It merely means you have completed the first step in the process of obtaining your green card and must wait for a current priority date to continue. The next step is waiting for the priority date to become current. Because of annual and per country limits on visas for preference relatives, the self-petitioning spouse or child of a green card holder may have to wait a long time, often several years, for a visa number to become available. It's a first-come, first-served waiting list. You're placed on that list, can be tracked using the priority date listed on your receipt notice. Until your priority date is current, you are not yet eligible to adjust your status to a green card by using Form I-485. Finally, the fourth step is to file for adjustment of status. Whether you're a preference relative with an approved I-360 and a current priority date or an immediate relative who has prepared your Form I-360, here's what you need to do next to adjust status to a green card holder. You must prepare and submit to USCIS by mail an I-485 application for adjustment of status along with supporting documents. Once you have successfully submitted your I-485 application for adjustment of status, you are considered to be in a period of authorized stay. Assuming you included Form I-765 in your adjustment packet, that's the form where you request work authorization, you will receive a work permit to last you until you get your green card. If you didn't include it, you can still submit Form I-765 along with your USCIS receipt notice for Form I-485. Within months, you will be called into USCIS office for an interview, at which time you will hopefully be approved for your green card status. Unlike regular family cases, your abusive spouse or parent or relative will not be required to accompany you to that interview. That is why it is called a self-petition. And this brings us to the end of our video. This is just a resume of how the process works to give you a bit of clarity, and you could know what to expect when filing for your green card under Vawa. But like I always mention, every case is different. It is always better to have a professional study your particular case so they may help you get the best results and avoid troubles that could lead to deportation. Are you planning to request a family-based green card? Then this is for you. In today's tip of the week, I'm going to tell you everything you need to know for getting your family-based green card. Join me. Hi, my name is Andres Mejer. I'm an immigration attorney and an immigrant. My family and I came to this country a long way back and lived here without legal status. We dealt with the problems this carries, the stress and preoccupation of getting into legal trouble or the risk of being deported. We had very bad experiences dealing with the immigration system, and we partnered with the wrong people that only made things worse. So you can trust me when I say, I know what you're experiencing and that I want to help you. That's why I became a lawyer, to help people like you have an easier path to legal status in this country than I did. Today, we're going to talk about the family-based green card and what you need to obtain it. So let's go right ahead and start with this video. There are a variety of ways you can apply for a green card in the US immigration system. There's employment, there's refugee asylum, there's diversity lottery, and of course, family-based immigration, which is the most common. In 2019, almost 69% of people that got a green card did it through a family-based application. The first thing needed to apply for this type of green card, as its name implies, is for you to be related to a U.S. citizen or lawful permanent resident. To apply for this green card, there is a handful of eligible relationships with a U.S. citizen or lawful permanent resident that you need to fall into. And these options are divided into two categories: immediate relatives and family preference. What's the difference? Immediate relative, there's a visa available immediately once your petition is approved. Family preference, once your petition is approved, you're going to have to wait for a visa. How long? Depends on the preference category. For the immediate relative category, there are only 3 options, and that's a spouse of a U.S. citizen, an unmarried child under age 21 of a U.S. citizen. So what I mean by that is if I'm a U.S. citizen, which I am, and my child is not married and under 21, he's my immediate relative. Now, my child can be by adoption, it can be biological, or it can be step relationship, meaning it's my wife's son and I married my wife before my son turned 18. So he's my child for immigration purposes, even though biologically he might not be. So spouse of a U.S. citizen, unmarried child under 21 of a U.S. citizen, and parents of a U.S. citizens who are at least 21. So if I'm applying for my son who's not a U.S. citizen, but I am, that's one category. If I'm not, I don't have legal status, but my child is, and he's over 21 and a U.S. citizen, then I'm his immediate relative. I know that's confusing. I apologize. I wish I could simplify it any more than that. You just need to memorize it. There's no 2 ways about it. They're very specific categories that are in part because an immigrant visa is always available for those 3. Besides the time it could take to submit your paperwork, the immediate relatives aren't subject to the long waits that other types of visas have. So there is practically no wait for that visa. The rest of the eligible family members fall into the family preference categories. For this grouping, there is usually a longer wait period, and that's because there's a limit of these visas available each year. The members that fall into this category are unmarried adult sons and daughters, that's 21 or over, of U.S. citizens, spouses and unmarried children, that's under 21, of permanent residents, meaning green card holders, unmarried adult sons and daughters of green card holders, married sons and daughters of any age of U.S. citizens, brothers and sisters of adult U.S. citizens. So what does this mean? Grandparents, grandchildren, nephews, nieces, uncles, aunts, cousins, and in-laws cannot be directly petitioned. Now, if you have a relative that falls into one of those categories, you can start the process. And the first part of this video is that your qualifying family member must request an immigrant visa to be available to you. So this is the person who's a U.S. citizen or lawful permanent resident is applying for you, but obviously they have to fit into one of the categories I explained. They are, I wish I could tell you they're logical, they're not. It just is what it is. Regardless of your family-based category, an immigrant petition must be filed. This is made by submitting Form I-130, Petition for Alien Relative, with the U.S. government. This form will establish the existence of a qualifying relationship and will make the request for the visa to be set aside. Like I mentioned before, an immediate relative will always have a visa available. Meanwhile, a family preference relative could wait from a few months to several years or decades to get their visa. This can depend on how many people are waiting in the same category, what country they're coming from, and when they filed. The next step for requesting the green card comes after the visa petition under the Form I-130 has been approved and an immigrant visa is available. It is now that the family member can request the green card, and you can request it either inside the United States or outside the United States, depending on circumstances. To request your green card outside the US, the most common thing is to go to an embassy or consulate. This is known as consular processing. You will need to submit your application and all the required documentation to the National Visa Center or embassy, and then a consular interview will take place by an embassy officer before granting you the visa. On the other hand, to apply for a visa inside the United States, the main requirement is that you have entered the country lawfully. This way you could use the adjustment of status process to apply for your green card. So you need to have lawful entry and you need to have an immediate relative applying for you, generally. This type of adjustment is usually more common to immediate relatives since a visa is always available. But then again, since every case is different, there can be an option for family preference immigrants to get their green card inside the US too, although this is less common. So, family-based application generally has 2 components. One, you got to document the relationship, file the I-130, show that you have a qualifying relationship to someone who's a US citizen or lawful permanent resident. And the second is the change of status. Change of status happens either inside the United States or outside the United States. Generally, for you to adjust your status inside the United States, you need lawful entry and immediate relative. So if your relative's a green card holder, generally, doesn't matter whether you entered legally or not, you're not going to be able to adjust your status inside the United States. Every case is different. If you want to talk about your specific case, give us a call. If we can't help you, we won't take your money. All of this may sound simple enough, but it's always good to have someone with the knowledge and expertise on your side to help you check all the needed forms, make sure all the qualifications are in order, and can help you create the package you will need to submit your request. Because even though this is one of the most common ways to get a green card, USCIS rejects almost 10% of all applications right away because something is missing or is done incorrectly, i.e. not signing the forms, or incorrect filing fee, or sent to the wrong place. USCIS denies many more applications and sometimes puts people into removal proceedings when they deny an application. If you want to talk about your case, if you have any doubts about this process, or have any other immigration questions, please contact us. We can talk about your specific case, and if we can't help you, we won't take your money. If you like this video, please give us a like and share it with someone who may find this information useful. Don't forget to subscribe to our channel so you can get all of our weekly immigration tips and updates as soon as they go live. Thank you so much for watching, and as always, stay healthy and be safe.